District Court of Appeal is now open. All who have business for this court, draw near, give attention, and you shall be heard. God save the United States, the great state of Florida, and this honorable court.
Please be seated. We begin with Teresa and David Pabst against Rachel and Harvey Meadvin.
Your Honor, if I can, hold 6 minutes back to the law. May it please the court. I'm David Weisenfeld. I'm here today with my partner, Fred Abbott, who representing Teresa Pabst, who is the plaintiff in the trial below. Teresa was injured in a violent motor vehicle collision, which the defendant, Rachel Meadvin, stipulated before trial was totally her fault, and that she was negligent, and therefore the trial below was limited to the issues of proximate cause, permanency, and damages. After a 5-day trial, the jury rendered a verdict for $23,000 only, despite, among other things, medical bills having been introduced in the amount of over $64,000, and we appealed. During the final argument of this trial, the defendant's attorney made a statement that was extremely prejudicial and violated 2 separate rules of how you do trials. One of the rules is that you can't ask for sympathy.
What was that statement?
And the statement was, quote, and he's talking about Dr. Sarah, which was our primary witness at trial. The statement was, quote, if you believe everything that Dr. Sarah said, then it's going to be a bad day for Rachel Meadvin, unquote. If you believe everything our witness said, then it's going to be a bad day for our client.
Counsel, in context, 3 paragraphs before, counsel talked about Dr. Sarah and said, Dr. Sarah gave this image that this lady is a cripple with some type of horrible spinal damage, and that Dr. Sarah pretty much gave testimony on everything in the world, I think even surgery. In context, then, isn't the lawyer there simply commenting on Dr. Sarah's testimony that said that the plaintiff was so injured that it, quote, scared the pants off of you? Is that really a golden rule comment?
I believe it is, Your Honor. I don't see how any innocent interpretation could be made of the words that it's going to be a bad day for Rachel Meadvin. Whether it's a good day or a bad day for one party or another is not something that that the jury is supposed to think about. Maybe justice is blindfolded. We don't look for the sympathy. We don't look for, we don't want it to be a bad day for her. The fact is, if they believe Dr. Sarah's testimony, then that's evidence, and that evidence should be considered in determining what the verdict is, not whether it's going to be a good or a bad day for their client.
Could you argue, if you believe their witness, they win? If you don't, we win. I mean, would that have been a proper argument?
He could have. I'm not sure. That would be a better argument, Your Honor. That would be saying it's a bad day for her, because when he said it will be a bad day for her, it's focusing on her, not who wins or who loses, but it's focusing on her, and it's saying if she has a bad day, why is she having a bad day? Because she's not insured. And there's a similar case, Your Honor, I was going to get to.
Well, if this is all, if these implications are so clear, why was there no objection?
There is no objection, Your Honor, because when the reality is, when you're a trial lawyer and you're sitting at the trial, and something like this is said, and if you're not so far in your notes that you miss it, which happens occasionally, then you have to make an instantaneous decision as to whether it can be cured, whether anything can be done about it, or by standing up and objecting, you emphasize it. And that could be the case. Now, this is incurable in any event, because the only way you could overcome the implication that there was no insurance is to have the jury, and then in this case it recently said that, have the judge tell the jury, well, and as a matter of fact there is insurance, and she's not going to pay for it alone. Okay? That's only.
I guess I'm struggling to even understand that. The golden rule argument is a little closer in my mind, but I don't see how you even infer a lack of insurance from that statement. I mean, how do you get there?
Well, here's in the Hollenbeck case, which this court decided less than 2 years ago, during the voir dire, the defense attorney said, quote, "I'm a consumer justice attorney, and I represent John Hooks, a merchant marine, not some fancy company, not some conglomerate." He said that. And the court said, this court, First District Court of Appeals said, quote, talking about that statement I just quoted, "Counsel's statements were impossible to refute at trial. It would have been clear error for the trial court to inform the Veneries Act. In fact, the appellee's counsel was retained by an insurance company to represent the appellee."
So that statement, or in that case, the statement he made was patently false. He was employed by a bigger conglomerate, right?
Yes, Your Honor.
So that was the problem there.
Well, I think it was a mention of insurance because you can't tell this jury whether they have insurance or they don't have insurance. In fact, there's no explanation as to why it would have been a bad day for Rachel Meadvin, except that is, trial lawyers understand this, Your Honor, that that's a signal to the jury. It's a bad day for her. Why is it a bad day for her? She must not be insured. It's a clever way to do it. It's a clever way to couch it, Your Honor, but that's the significance of it.
It may be significant to trial lawyers, but to the average person sitting in the jury, wouldn't they reasonably infer that to mean it's going to be a bad day for her if she loses this case?
Well, I don't agree, Your Honor. I don't think it is, but if nothing else, at least I think the court will agree that they're asking for sympathy. It will be a bad day for her. What else is that but saying, "Don't hurt my lady"? It'll be a bad day for her if you believe Dr. Sarah. If I can remind the court, and I ask the court's indulgence in reading this because I'm sure you know it very well. As far as standard jury instruction 7.1 says, in reaching your verdicts, and there's a reason I'm reading this, if you'll give me a moment. In reaching your verdict, you are not to be swayed from the performance of your duty by prejudice, sympathy, or any other sentiment for or against any party. Your verdict must be based on the evidence. You must argue the evidence, not the effect of the evidence on one party or another, or whether it's going to be a good day or a bad day for them.
Was the jury read that instruction in this case?
I'm sure they were, Your Honor. I wasn't at the trial, but it's my understanding that they'd be amazed if they were.
So wouldn't that then, in conjunction, wouldn't that cure any potential prejudice coming out of this? If we look at instructions as a whole, and if on one hand they were told, "Take care of my lady," and the other hand they were specifically told, "Don't base this on prejudice."
In a perfect world, it would, Your Honor, but I don't think that's the way it was. I'm sure they read that instruction in the case that's very familiar to our firm called Poacher v. Glass, which is a 2004 decision, once again, from the First District Court of Appeals. Judge Webster, I believe it was writing to the court, and he made a statement with regard to this particular jury instruction, and he said, quote, "If we are interested in the integrity of the process by which a jury determines disputed facts, we must not allow this instruction to become mere window dressing for a procedure that can be steered all too easily into a morass of prejudice, sympathy, bias, and emotion." Unquote. This court took a strong stand against appeals to sympathy during the course of the trial, and specifically during the final arguments. And it's a stand that should be taken, and we understand that, and we think it applies both ways. You cannot say, feel sorry for my client.
Which of the cases you're relying on where there was no objection do you think is your strongest case?
I don't have one specifically with no objection, Your Honor, but I think we complied with the criteria of the Murphy case, the 2000 Supreme Court case, that laid out the 4 criteria for when there is, even though there's not a contemporaneous objection, you still preserve it for appeal.
But explain to us how this argument, and I use the language of Murphy, quote, "so damaged the fairness of the trial that the public's interest in our system of justice requires a new trial." Because that is, as I read it, a very high barrier.
It's a little bit vague for me, Your Honor, but I take it as basically a statement by the Supreme Court that the district courts are to determine, almost in the sense of a public policy for the court system, seems broad, that you can determine that where an attorney goes wrong, goes astray on this kind of issue. For example, everybody knows that the bar associations meet, the other plaintiffs bar and the other defense bar, and this is an adversarial process, and both sides are trying to do everything they can to win the case. And if you can win the case and make statements like this that are blatantly wrong, a blatant attempt at sympathy, even if you don't agree with what we're saying with regard to insurance, although we think that's clear too, a blatant request for sympathy, if they can make a blatant request for sympathy, they're going to do it every time. Lawyers in this system are going to go where they can go, where the courts allow them, and the only thing that's going to hold them up, the only thing that's going to stop them is what the courts decide and where the courts go with this. And we're asking for the court to make a strong stand.
You're well into your rebuttal.
I'm sorry, Your Honor. Well, we have three other issues. I knew we couldn't get to them. I think they're very well briefed by both sides, and so we're not waiting down and not arguing them during this period. Thank you.
May it please the court, my name is Mark Tinker. I'm the member of the Gas and St. Petersburg. I represent Rachel and Harvey Meadvin. On the one issue that's been argued today, the court has kind of acknowledged it. Of course, there was no contemporaneous objection or any objection at any point thereafter, so we have to apply the Murphy test. It's the four-part test, of course, the court is aware of. First of all, I don't believe that this statement, as innocuous as it was even an improper statement. Again, real quick, I agree with you. If you look at the context, and especially if you look at Dr. Sarah's opinion and how extreme, I think it's safe to say his was by far the most extreme of the opinions that was offered at trial. If you look at it in the context of the closing argument and the way it was made, it was not a reference to insurance or an appeal for sympathy. It was simply a comment on Dr. Sarah's testimony.
And I'm inclined to read it, it's interesting, in a very different manner than Judge Weatherall. I read it as a comment on the fact that Dr. Sarah is correct, and the plaintiff is in such bad shape, she's going to have a bad day with her physical condition, not that she's going to lose the trial. Believe Dr. Sarah, she wins the trial. She got a good day from that. So here is the defense counsel saying something that arguably benefits the plaintiff, if you look at it the way I did.
And I think,
I must admit, I have a hard time even understanding what he was talking about, but so I have some sympathy for the appellate here, but it's unclear as much.
well, that's really, I think, a part of the point is you have, the two judges sitting here, and you can't decide even what it means, and, you both kind of interpret it different ways. I believe it's safe to say that we can't say that the jury necessarily interpreted it the way that Pabst says that they did, and that this was really the end-all, be-all of the entire trial. This is why they made their minds up the way that they did. Going back, I think this is something that, as I was going through my notes, getting ready for today, looking at the second part of the Murphy test, is was it harmful? The claim of harm is that there was sympathy because it implied that she didn't have any insurance, and that this jury must have therefore believed she had no insurance. I saw a couple things interesting in my notes, looking back through the trial. The first was when one of the doctors, Dr. Kushner, was testifying. He was asked if he knew that Pabst had gone to see another doctor, Dr. Kilgore. And the statement, the question was phrased, quote, that she went and saw him. And Pabst counsel objected to that and said, well, wait a minute, that implies that she treated with him. And that's not true. He just did an examination. So then his counsel said, I'm going to clear up the question. Do you know Dr. Kilgore? Yes. Are you aware that she was examined by him? And the witness, Dr. Kushner, said, oh, well, yes, I know Dr. Kilgore very well. I know he doesn't even treat patients anymore. He only does examinations for insurance companies now. I know him. So that was thrown out to the jury during the trial. A little bit later on, Pabst counsel was questioning Dr. Grudem, a treating physician, asked him if he'd used the video surveillance that had been taken of Pabst. He said, yes, I'm very familiar with surveillance. I worked in the insurance industry for 6 years. I know all about surveillance. So the jury heard that as well. So the jury is being told over and over through the trial that there's insurance here. So I think if you look at, was this truly harmful? I don't believe it is, because there's, I think, direct evidence that there was insurance, and they want to believe that this one doctor's statement implied the contrary, and that made the jury make up its mind. Looking at whether it's incurable, you asked, where is there a case that it's a no objection case where it was found to be incurable. I found only one case that addressed the situation as Mercury Insurance versus Moretta. It was out of the 2nd District in 2007. That was a case where insurance was injected into the trial, and the 2nd District's quote is, generally speaking, improper references to insurance matters in closing argument may be cured by an appropriate instruction to the jury from the trial court, end quote. So, had there been an objection, counsel could have gotten a curative instruction, that would have cured it. It's not, this isn't something that's incurable. And, you know, in my mind, we look at the way the Mercury test works and looking at closing argument issues. If there's something that's just so fundamental that it's going to just taint the entire trial, it's going to end it, there's no possible way you can get a fair verdict, I think it's counsel's obligation to bring that up before the actual verdict comes in, to bring that to the judge's attention, ask for a mistrial, say this thing is over with, it's tainted now. You can't wait until after the verdict, see whether you like it or not, and then decide whether you want to use this as a second bite at the apple. And then, of course, the 4th element, whether it's so damaging to the fairness of the trial that the public's interest in our system requires a new trial. I don't believe there's one statement here that comes close to that. I haven't, in my research, found a single unobjective true statement that satisfied that test since Mercury came out. I'm not sure what it would be so damaging in that regard. But needless to say,
Did Mercury clarify the law? Did it change the law? Justice Lewis writes a great deal in there and starts off with the premise that some of the DCAs were taking the position that there really is no exception for unobjected to closing argument. If you don't object to it, you really waived your point on appeal. So I guess to that extent, they clarified, but it still as high a burden as Judge Klein wrote in his law review article.
I believe it is, and I know the quotes that the Mercury court used is supposed to be a very narrowly parametered escape valve that's only supposed to be used in the most extreme cases. I think I agree with you, it was a clarification. There are some courts that are holding that no way, if there's no objection, there's no possible way of raising on appeal. There were others that were still applying fundamental error analysis with regard to certain statements. So I think Mercury just clarified this is the 4 elements, this is what you look at. And I don't believe that this case satisfies anything that most of us on board.
Could you talk for a minute about the mandatory issue that the jury came back with a $20-some-odd thousand verdict, and there were stipulated bills of $64,000. Clarify what your position is on that issue.
The stipulation was as the amount of the bills, not whether the accident caused them. And where that came about is the original bills were, I believe, in the 80s or $80-some-thousand, but some of the providers accepted Medicare as payment in full. And so we know that when they accept that, there are certain amounts that's written off, and plaintiffs can't introduce that as evidence the trial does not bill damage. They didn't incur the amount of bills that was written off. So before trial began, nobody really knew what that number was, specifically what the write-off was. By about the 3rd day of trial, Pabst counsel had figured it out and announced, this is the number, we all agree this is the actual amount of bills that she owes. The stipulation did not extend to did the accident cause those, because of course you look at a lot of what was argued at trial, some of those bills are for treatment for her claimed closed head injury, and of course evidence denying that she had any closed head injury at all, so those bills would not be related, and I believe that
So your view of the stipulation is that when this pile of bills, in my mind, that's what I picture, went to the jury, the stipulation was that pile is comprised of $64,000, and the jury, you figure out how much of that is related to this accident. Is that your interpretation of the stipulation?
Correct. That was the stipulation. That is how much she owes her providers. Why she owes that amount? Is it from this accident or is it from something else? That's for the jury to decide, but that was the amount.
Counsel, on issue 2, where the counter argues that there was error in the trial because the weight of the evidence was contrary to the jury's mind, the counter argues that there's no medical evidence to dispute the testimony of Dr. Sarah, and therefore the jury's finding was contrary to the manifest weight of the evidence. Would you address that?
Their argument is that Dr. Sarah was the only doctor because he was a psychiatrist. Board-certified psychologist Harold Smith Jr. directly testified that there was no closed head injury and no cognitive impairment, and that's what they're arguing about. They've kind of abandoned the back and neck just a closed head injury is what they claim there was no evidence of. And again, that's a direct opinion.
The psychologist was accepted as an expert witness to testify on whether there was a closed head injury?
Yes, he was. He performed some testing on this past, performed cognitive testing. He said that she passed everything. He found that there was no cognitive impairment and therefore no closed head injury. Outside of that, there was other ample evidence. The emergency room doctor who examined Pabst immediately following the accident was called in to testify, said that she passed all of the tests for closed head injury at the scene, scored a perfect score. I forget the name of the test, it's somewhere on the long name. Scored a perfect score. Said the only thing she had was a complaint of a headache, which the evidence also showed that she had complaints of headache in the past 11 years before this accident ongoing. He said the only thing was a complaint of a headache, so we ordered a CAT scan, the results were normal. Other physicians, a couple neuroradiologists came in and said that all of her brain scans were normal, didn't see anything there. Even Dr. Sarah, the expert that they labeled as positive, admitted on cross-examination that he could not rule out the possibility that her brain injury predated the accident, because there were some other experts that came in and said, well, we do see some features on these brain scans, but they were there before the accident. So Dr. Sarah said he couldn't rule it out. And I think, if you're looking at the manifesto of the evidence claim, I'm getting the boilerplate that the court's not to act as a second juror, veto power, and you have to consider the superior vantage point of the jury. They got to view the witnesses, assess their demeanor while they're testifying. We're, of course, going to make a transcript here. And, if you look at everything that the jury saw in total, they saw that her main complaints are headaches and depression. She was complaining of headaches before. She was on antidepressants before. You look at all of the evidence, the jury could assess the credibility of everyone. They can weigh the evidence and make a decision, and the jury did that. I believe there's ample evidence supporting the decision. And I think directly, as I said, by Harold Smith Jr., he gave a direct opinion.
But the MRI and CT scans were basically inconclusive, is that correct?
They were disputed. Some experts said that they didn't show anything. Some said that they did show things, but again, that they predated the accident. Some experts said, well, you can't necessarily even see it, whether there's going to be cognitive impairment from looking at the film, and that's why Dr. Smith did the cognitive impairment testing on her for her battery test. So there was evidence disputed all over the place, and again, I think the jury could appropriately resolve it the way they did.
And this is not the only automobile accident she had ever been in.
No, she was in a rather severe one before, and that's when her complaints of headaches actually started. It was following that accident, and continued for the next 11 years up until this accident. She claimed that her cognitive impairment, at the time of trial, claimed her cognitive impairment left her unable to even drive a car. Following this accident, she continued driving for 2 years, so she was involved in the third accident where she went off the road and the driver cycled over a car, hit a tree. She stopped driving then. So there's a lot, definitely, outside of the opinion evidence and the experts, there's a bunch of lay evidence the jury heard that supports this as well.
Including evidence of her falling from a human pyramid.
Right, but I think that was probably more related to her back and neck complaints. I don't believe she claimed that she hit her head in that event. She fell down on her, struck on her tailbone, as I recall. If the court doesn't have any further questions, I'll do it with that.
All right, thank you.
Your Honor, I'm Fred Catfish. I was the underlying trial lawyer. In 31 years, I've only done 3 of these. Is it permissible for me to do rebuttal?
Yes, you may.
Thank you, Your Honor. And I can answer some of your questions, Judge Wetterall, and particularly in regard to why there was no objection. But let me preface that. I was a plaintiff's lawyer in Boker, which is court reversed. It was a $3 million judgment for improper closing arguments. So I'm very sensitive to the law in regard to closing arguments. At the time this statement was made, I had to make a tactical decision that they were going to try this case on the sympathy level. And it's been my experience in over 129 jury trials that once that sympathy bell is unrung, you can't unring it, whichever side of the street you're on, plaintiff or defendant. So I made that decision that they were going to a place of sympathy. We knew, everybody knows, there were millions of dollars of insurance in this case. In regard to Dr. Sarah, he was the only psychiatrist in this case that testified. And what they took out of context, he didn't say that she may have been injured in a prior collision with the brain. He said that she has a permanent injury within a reasonable degree of medical probability as a result of this collision. So it was objective forensic evidence.
Wasn't the jury free to just reject that?
Absolutely. But when you talk about the manifest way of the evidence,
There was an MRI that showed brain shearing. It was taken right before the case that went into evidence. And when we read it, they objected, and the judge said, you're not going to talk about that anymore in this case. In regard to the burden of proof, I think the other points that you alluded to, the remitter and those things, all add to the gravamen of this case. In other words, that the evidence was overwhelming for the plaintiff in this case. They made a tactical decision not to call a psychiatrist and have him do independent or a compulsory medical examination. And the doctor that they're talking about is a PhD, not an MD. Florida law indicates that for physical injuries, you need to be a medical doctor to testify on causation. The only medical doctor testimony in this case for brain injury was from Dr. Sarah.
Counsel, that's why I asked the question that I did about a psychologist testifying to something that at least my lay view looks like might be outside of the person's training.
Right. And I thought
that objective.
I filed a motion in limine to prevent him from talking about injury and causation. And they sort of backdoored that. They said, I did these tests, and I can't see any cognitive impairment from a closed head injury. That's his exact testimony. But he cannot render, I believe, under Florida law, an opinion on physical injury and proximate cause, because he's a PhD and not an MD. And I can answer one of your questions, Judge Weatherall. I thought it was a good one about the jury instruction being given. There are a plethora of jury consultant studies that show the average mentality of a jury is between the 4th and 7th grade. They're not functioning on our level. We understand instructions, their purpose, and their meaning, and of course they've just been revised by the Supreme Court. Those studies indicate that juries summarily and immediately ignore jury instructions. What they do here is sympathy, and what they are people functioning in regard to prejudice. And when they made that decision in closing, I had to make a tactical decision. And because of the Boker case, I do not go anywhere near it. That was a $3 million verdict. And our position is that if the appellate courts are going to reverse the plaintiff for this, they need to do the same thing to defense attorneys for making those kinds of statements. And the other issues in the brief, go ahead.
Statement in the Boker case.
Pardon me?
What was the particular statement in the Boker case?
Well, it was the wrongful death of a child, and it was a magic button argument that it was about money for the wrongful death of a 19-year-old. And we had asked for $3 million. And on rebuttal, the statement was, if you had a magic button and you had this money, my parents or this 19-year-old child would walk right by the button. right by the money, push the button and get the child back.
You would agree, would you not, a lot? This statement is a little more innocuous than that.
Well,
it's patently obvious that that's the innocuous.
Yes, I would agree. But you have to understand the context. Rachel Meadvin was a young girl in her 20s. She didn't testify in this case, and that statement was made solely to imply that it's going to be, the verdict was not going to affect her at all. She didn't even testify in this case. Neither did her father. Neither of the defendants testified. There was ample insurance coverage in this case.
Mr. Abbott, one of the concerns I've got here is that certainly in your reply brief, really excellent argument about Hollenbeck and why it should be the case that we find persuasive here. But I'm struggling with the fact that in Murphy and in some prior cases, the Supreme Court has created obviously a higher standard where there's no objection. I certainly understand the strategic bind that puts you in. But here we are with Murphy, and Murphy creates, help me get over that area.
Thank you, and I will. And here's our position, that the courts have clearly made a bright line in regard to closing arguments, and that this is not how trials should be decided on a talented lawyer making an impassioned plea for sympathy or prejudice against either party. And that's the fourth tier of the case you're talking about, Judge. That's the significance of this. If we're going to allow people to say, plaintiff or defendant, it's going to be a bad day for my client if you rule against them, and that goes to Mr. Cupp, they had filed a motion limiting preclude insurance. We know that's the law. Okay? But those people on the jury are thinking, well, why is it going to be a bad day? Does she have to pay this? And the answer to that fourth tier question in that case is that that's what's going to happen is that people are gonna start creeping up to that line that you folks told me do not cross in the Boger case in 2004. That's the significance of it.
All right, Chairman, I think we have your position.